Hi, I'm Kirk Evans, president of Texas Law Shield. We're here today to talk about what is called the Texas Civil Liability Immunity Statute. Texas has a statute, and it's 83001 of the Texas Civil Practice and Remedies Code, that provides that if you are justified in using deadly force, that you are immune from liability for damages for personal injury or death arising out of the use of that force. Now, what does that mean? Does that mean you're immune from being sued? No, it absolutely does not. In fact, the Texas Appellate Court has said that this does not provide immunity from suit. It only provides immunity from damages down the road from that conduct. Okay, so what does that mean if 83001 is not an immunity to lawsuits? That means you can be sued for using deadly force against someone. If you are sued, you need to plead and prove that defense. So what does that mean? Typically, you'll have to retain an attorney, and in the papers that you file to answer that lawsuit, you need to assert that defense of immunity. Then you'll need to prove that defense. That could be in a motion to dismiss, a motion for summary judgment, or even at trial. You'll have to set forth the documents, evidence, witnesses, authorities, arguments, things like that, necessary to show the court that you were justified in using your firearm in self-defense. Sometimes you'll be able to do that early in the case with a motion to dismiss or a motion for summary judgment. Other times you may not be able to obtain a ruling on that defense until after the final trial is finished and after the jury has made a determination that you were justified in shooting. The law is slightly different, however, when it comes to third parties. So say you fire your weapon at an attacker, you miss with a shot and injure someone across the street. Are you immune from the damages you've caused to that third party? Yes, unless you acted recklessly. So what is reckless? There's no bright line that tells us what reckless is. It is whatever the jury or the judge decides at the end of the day. Some examples that are commonly found to be reckless are haphazardly firing multiple shots into a crowd of people. Similar circumstances could cause a jury or a fact finder to determine that you were reckless, and you might be liable to that third party, even though you might be justified in firing your weapon in the first instance.